Okay, we're ready to turn to our troikas. The first one is Tom Colby, David Upham, and Judd Campbell.
Okay, two quick questions. The first is, I'm having trouble understanding from the paper, what was the theory that would have led the Republicans to think that limiting the scope of the Civil Rights Act to citizens alone makes it more likely to be constitutional under the Due Process Clause, or an inherent authority to enforce the Due Process Clause, given that the Due Process Clause applies to all persons, not to citizens? I just didn't understand that piece of the puzzle. The second, more provocatively, question about implications. If you are right, does that mean that federal race discrimination and segregation was already unconstitutional from 1791 forward under the Fifth Amendment Due Process Clause? Was Bowling versus Sharp correct? Or maybe, to flip the question even more provocatively, your evidence seems to suggest that the equality guaranteed by the 14th Amendment does not include racial equality in jury service or a right to school integration. Does that mean that Brown was incorrectly decided as an originalist matter?
David Upham.
Several points. It's complicated because I'm always saying yes, but every time, almost every page of your paper, I'm saying that's right. Oh, that's not quite right. Declaration, equal protection, due process. Your last comment about the close relationship between due process and declaration principles was closer, but I'm wondering if you're maybe getting the genealogy wrong, that in American law and American culture, people are far more aware of the Declaration of Independence and principles like that restated as the first article of the state constitution, Bills of Rights, not just in the founding era, but in the whole Civil War era. One state after another in the South or the new states in the Midwest, they place those in a primary place. So there's a Section 5, Fifth Amendment Due Process Clause is one exemplar of the principle, and and you also indicated that equal protection is maybe included. It's not so much that equal protection is included in due process; it's that life, liberty, and property are included in both those clauses. That they're the two of the chief children of the Declaration principle of natural rights, rather than due process includes them. I thought that the second point is it's an issue that's very that makes the whole issue of interpreting the Civil Rights Act complicated for me, and I haven't been able to deal with it. But it seems to me that perhaps you could try to deal with it, and that is the whole thing is really not. It's an enumeration of rights, but all under the banner of no race discrimination with respect to these things. That is to say, the Civil Rights Act is primarily no race discrimination, and then secondarily these enumerated subparts. So that it would be more to say that it's no race discrimination, well, at any rate. And lastly, the evidence of I think you're right to try to take the Civil Rights Act out of the privileges or immunities clause, in the sense that it was understood to be just that's where it is in Section 1. In part because, as you indicate, Section 1 is typically, there's typically not a distinction between the clauses. It's just kind of, oh yeah, that's a Civil Rights Act section, and it's maddening. It's maddening. I wish these guys would can I just talk to you a little bit more? Can you explain? But the reason I think it's primarily but not exclusively in those second two clauses, because you indicate all this evidence where people are talking about privileges and immunities, including all the evidence where people have to say, no, that's not the case, including United States versus Rhodes, which means the lawyers were arguing it. So that this is something that's out there. It's one of the things that's being, in my opinion, they're throwing it against the wall. They take the naturalization clause, the Section 2 of the 13th Amendment, something to get this kind of law through. And privilege immunities is a big tertiary or maybe secondary argument. And it helps to understand, if you will, the Civil Rights Act property acquisition stuff. It's very hard to stuff that into due process equal protection. It's very easy to stuff that into privileges of citizenship. But conversely, as you indicate, it's very hard to stuff the equal security in life, in person and property into privileged immunities and not see it looks just like the due process equal protection stuff. So primarily, but not exclusively. It seems to me more the evidence you indicate supports that thesis more than it's due process and not privileges or immunities.
Yeah, so I think it's really important to separate the concept of natural rights from the concept of due process. So the way that I read the evidence in the paper is that there are pre-existing natural rights to life, liberty, and property. These are autonomy interests of a sort. They're not rights they're not legal rights. They're autonomy interests. And then the government is established to guarantee those interests in two different ways. So one is against governmental action that unduly infringes on your rights. So if the government were to take possession of me or my property. And the second is to protect against undue private infringement on those autonomy interests. So if somebody were to take me or my property, then I bring a tort action or a property action or some sort. And so I think of due process rights, so now we're not talking about the natural rights of life, liberty, and property, but rather due process rights as protecting against governmental infringement of my natural liberty, and protection rights as being a guarantee of certain avenues for redress for the abridgment of my life, liberty, and property by private individuals. So what I see the argument as being that you're finding in the historical materials is people are saying, okay, there's a Fifth Amendment due process right. That right implicitly recognizes the natural rights of life, liberty, and property, and in fact elevates them to the status of federal rights. The problem with that argument is it proves too much, because once we elevate those rights to the status of federal rights, then not only are they guaranteed against federal abridgment, and not only are they guaranteed against state abridgment, but we actually have a federal responsibility to protect them against private abridgment. And so we would then have a federal power to pass contract remedies, tort remedies, property remedies, etc. And so I think the 14th Amendment does something narrower, which it says we're dealing with the governmental abridgment of your natural rights through the due process clause. We are guaranteeing the equality of the protection of tort remedies, etc., through the Equal Protection Clause, but we're not recognizing a freewheeling federal authority to initiate tort law, etc., at a federal level. And so I wonder if the, maybe I'm wrong about all that, but I think that the paper would benefit from at least grappling with, well, maybe there's a conceptual difference between the natural rights of life, liberty, and property that are implicitly recognized by the Due Process Clause, as opposed to just calling life, liberty, and property due process rights.
Thank you. Okay, just in reverse order, Judd, that's very helpful, and I do want to address that. In some way, I put it in the category of how is this supposed to work? And as I understand the evidence, however they understood it to work, it would not allow for some type of, as you put it, freewheeling federal authority over the substance of tort law and contract, these private interactions. I think that's exactly right, and they had to move very carefully, or they weren't going to get support. They weren't going to override the presidential veto. They weren't going to get support at all, because you had a lot of conservatives and moderates in the 39th Congress who specifically said, we're not going forward with anything that gives that type of authority over those particular subjects, that allows the federal government to control their substance. That's another reason why Bingham and a lot of other moderates successfully got the proponents of the Civil Rights Act to remove the language of civil rights and immunities, because it seemed to suggest that type of federal authority over the substance. So you're right. So how exactly was this going to work? And it would require some type of nuanced understanding of natural rights versus due process rights, and the role of the government, and retaining certain substantive control over the rights in the states. That's all part of where I want to go next, right? What was their understanding of due process? How does it fit with other statements they made about federalism and the separation of federal and state power? So it's a great point, and it's something that I wonder about as well. I don't find that to be in any way antithetical to any of the arguments in my paper. I just think that it's an implication that needs to be worked out. David, also good points about about the Declaration and the Fifth Amendment being an exemplar, right, to get our genealogy correct. And again, I don't find that antithetical to the arguments in the piece, that they did believe that the Declaration was saying something primary, right, to which the Fifth Amendment then tries to specifically entrench in the Constitution. If there's something, if you do see something there in terms of problematic about what I'm saying about the Declaration of Independence and its particular role, I would want to talk to you more about that, because I'm not trying to. The Civil Rights Act being about race discrimination as opposed to due process rights, I think is very intriguing. And again, it highlights, I think, one of the implications of the paper, that this equality norm would have been understood as an aspect of due process. And I think they were primarily concerned about the equality norm because they believed that the due process rights were already being protected. The key wasn't to get the states to provide due process. They just weren't providing equal due process for the freedmen, right? And their concept of due process was that as much as the case would allow, and that was the language that they'd use, as much as the case would allow, all persons should have equal process to protect against deprivations of life, liberty, and property. It's very, and then that raises additional questions from there. What then was the separate role of the Equal Protection Clause? Do they overlap? What equality principle do we find in due process that we don't find in the Equal Protection Clause? I've been reading Michael McConnell's work on due process as separation of powers, and I noticed that Michael and his co-author also recognize this equality principle, this need for generally applicable legislation. It's there, and other authors have, other scholars have noticed it as well, but no one has developed a theory of equality out of the Due Process Clause, even though courts have occasionally hinted at it in cases like Bowling against Sharp. The property rights omission is very interesting. Citizens and aliens both had the right to acquire and possess property and be defended against deprivations of their property without due process of law. But the way that played out in the common law was different depending upon whether or not you were a citizen or an alien. Aliens, in some states, aliens had the same rights as citizens to acquire and possess and hold real property. But in other states, they didn't. They could only hold real property subject to office. That would mean that the government, on certain occasions, could actually step in and repossess the property. So I think that the omission of that specific real property rights, leasing and holding real property in the 1870 extension, simply recognized that due process property rights were rather nuanced when it came to citizens versus aliens. And so they didn't take property rights out. They just kept the catch-all phrase of the general protections of persons and property. Right, and so so judges go work it out, right, and work out exactly how that's going to apply to aliens. Tom, first of all, why did limiting the Civil Rights Act to citizens get you to the Fifth Amendment? That was based on the Prigg theory, and this was a big part of Wilson's argument. The Prigg theory was handed down by the Supreme Court in the antebellum period, which looked at the Fugitive Slave Clause of Article 4 as establishing a right of slave owners to reacquire their slaves. It didn't have a specific power associated with it for Congress to enforce that right, but in Prigg v. Pennsylvania, the court read the clause to imply congressional power to enforce this constitutional right. And so what you would do then is that by turning this just to citizens, now you could take advantage of the Prigg theory. All constitutional rights of citizens now came with their own implied power. They gave Congress power to enforce them. So he could say, and he did say expressly, what was good for the goose was good for the gander. We would enforce slave rights under Prigg. Now we're going to enforce the rights of the freed, the rights of citizens. Where do we find the rights of citizens? We find them in the Bill of Rights, and we find them announced in the Fifth Amendment. And the Fifth Amendment was specifically described as announcing one of the rights of citizens that Congress had a duty to protect. So even though you didn't have the specific linking it to citizens doesn't expressly talk about the Fifth Amendment. They understood that linking it to citizens made the prig theory available to them to enforce any enumerated rights of citizens anywhere in the Constitution. In this case, it'd be the Fifth Amendment. Was racial segregation always unconstitutional from the very beginning? I have argued in prior work that the 14th Amendment, and in particular Section 1 of the 14th Amendment, re-adopted the rights of national citizenship to the extent that we should be enforcing 1866 and 1868 understandings of free exercise of religion and non-establishment of religion. So in other words, I believe it did have an impact on the original understanding. And so so my first answer would be, I don't know, but I don't care. What I would look for is what were their understandings of due process, and that they would have the right to entrench their understanding of due process. And even if it was a contested issue before, and it certainly was, this equal protection component of due process now is entrenched, and it was as true for the federal due process rights as it would be for the state due process rights. That's a big theoretical move, right, to say that this has actually changed the shape of the original Bill of Rights. And it's been a theoretical move that I've played with, but I've never developed at length, and I should. I should defend that and see if I can come to some type of sensible theory of refounding. What about Brown? Are we back to Brown? Maybe. It's quite possible to take into, this is the big argument that Michael and others have been arguing about, that if we're going to take seriously the understandings of due process and equal protection that were in play in 1866 and 1868, there's a lot of racism. There simply is a lot of racism, a lot of separating out of what they thought were social rights that were not covered by the amendment, certainly not political rights. Racial equality and those were completely separate, and they tried to draw those distinctions. And that raises enormous problems, I think, and I continue to think it raises enormous problems for reading Brown v. Board as part of the original understanding of the 14th Amendment. I appreciate the efforts of others to work with that, but I simply take your point quite seriously, and I'm not sure where the evidence is going to take me. That's going to be part of my, how does this play out, and what is our theory of due process, and what are the implications for the modern era? And so point taken. That's something that will have to be addressed.
John, did you want to?
No, that's all.
Okay. Second troika is Chris Green, Larry, and I'm going to let him pronounce his last name, and Guy Burnett.
Okay, so I have 15 points here. John hit 5 of them, and I'm only going to talk about one of those. So I'm not going to hit everything. But so a lot of people did say it was privileges or immunities. So you cite my article saying, well, nobody said. So I go through like 9 instances, and most of them are equivocal, but there's a couple of them I look at them like, are you saying privileges or immunities? Elliott, I think one of the others, the Howard evidence you cite at 2896. This is where he jumps up and helps out Fessenden, and he says, we wanted to make citizenship and the rights of citizens under the Civil Rights Act clear. And I mean, to Kurt's credit, he quotes it, but then just the explanation here, I just don't see it. While we're talking about Howard, the bit where I said, well, maybe this means all of Section 1. You say, that's kind of counterintuitive. Actually, on Kurt's view of the Privileges or Immunities Clause, which includes the Fifth Amendment, the Privileges or Immunities Clause actually is one of the clauses also doing the work of constitutionalizing the Civil Rights Act. Because you've got the Fifth Amendment itself being incorporated for citizens, the Civil Rights Act of 1866 doesn't give you any explanation for why we have a due process clause in the 14th Amendment. So when Howard says this gets rid of all class legislation, it seems perfectly sensible, even on your own reading, even on Kurt's own reading, to be talking about all of Section 1. Moreover, if he's talking about 2 clauses, why would he say this instead of these? So further, I give a bunch of arguments. I say, well, then he jumps in to talk about citizens immediately after that. So I get a bunch of arguments in the Mason piece. So just say, well, it's counterintuitive. I mean, read the Mason piece and see if it makes sense. We talked about Schuyler Colfax during the campaign. Again, it's quoted in Kurt's book. I mean, Colfax says, we passed a law on April 9th that says what the rights of citizens of the United States are. Thaddeus Stevens says, if you want to know what the Privileges or Immunities Clause means, go to Schuyler Colfax. He's the Speaker of the House. Finally, this is the last thing I'm going to say. Zachariah Chandler's evidence that you quote, he's the other senator from Michigan. You say, well, he's clearly talking about persons, therefore clearly talking about due process. He says, this is equality for all people. I mean, I was trying all morning to download the exact context, but he says roughly, equality for everybody, black or white, native-born or naturalized. And when he says naturalized, so I actually cited Chandler as saying he's saying it's privileges or immunities that's doing the Civil Rights Act. I mean, it just seems that evidence just supports that. So when he says when he's specifically limiting it to naturalized, he's talking about citizens rather than persons. I'll stop now. Oh yeah. I'll stop.
I assume it's Solomon, not Alexander.
No, yes, oh, yes, yes. Alexander I can pronounce, no problem.
Kurt, so just a suggestion, a big suggestion, right, that it's a very long paper, and I'm wondering whether or not you really want to try to make this paper do all the things that it's currently doing. You might write a much more focused paper on sort of the narrower question, whether it was the self-understanding of the participants in the process that led to the drafting and congressional proposal of the 14th Amendment, that it provided a constitutional basis for the Civil Rights Act. That paper could sort of have a narrower scope, and in particular, it seems to me that of the things you're doing in the paper now, many things that come very late could come earlier in that more narrowly focused paper, and in particular, things like the Doolittle and Grimes exchange on page 87. If you did it that way, then that part of the paper could be that new paper would allow you to more fully examine the implications of that evidence. This is the exchange, for those of you who don't remember Doolittle and Grimes, this is the exchange where Doolittle is saying, I have a right to infer that it was because Mr. Bingham and others of the House of Representatives and other persons upon the committee had doubts, at least, as to the constitutionality of the Civil Rights Bill, that this proposition to amend the Constitution now appears to give it validity and force. And Grimes replies, it's an imputation upon every member who voted for the bill, the inference being legitimate and logical that they violated their oaths and knew they did so when they voted for the Civil Rights Bill. So this would be an example of a performative contradiction, right, that by enacting the Civil Rights Act, there's a presupposition that the Civil Rights Act is constitutional, but by enacting the 14th Amendment, there was a presupposition that it was for the purpose of constitutionalizing it. There is a presupposition that it's not constitutional. That's a performative contradiction, and that impugns the character, therefore, of the people who engaged in that act. And from that, Grimes says, and therefore, that's not what we were doing, right? All of that can be thought out, I think, in a much more rich and nuanced way, what the actual implications of the evidence are. There may, and for example, it might be that you need to say something about whether or not the performative contradiction actually supports what Grimes says, because you can read it exactly sort of the opposite way. So that's comment number one, is sort of you could then focus on that. then paper number 2, I think, is actually about much more focused on the due process clause, right? And just by coincidence, presupposition, I think, is the key to your argument here, right? So as I understand your position as you've articulated it in the paper and what you've said today, your reading of the due process clause responds to a natural objection, right? That, hey, the due process clause is only about deprivations. This is similar to some of the things that have already been discussed, and you're talking about it in this very different way as a clause that somehow establishes these rights to life, liberty, and property. But my understanding is that that's not actually your position, and that objection does not actually contradict what you have said. What I understand you to have said is that the due process clause has a presupposition that you can't meaningfully talk about a provision that says you can't deprive people of life, liberty, or property without due process of law, without presupposing that there are these rights to life, rights to liberty, rights to property that pre-exist and are presupposed by that language. That presupposition then would undergird both the 5th and 14th Amendment. And it seems to me that you have, in fact, an entirely consistent position here. But if you separate out into 2 papers, then once again, you would have the room to more fully develop the implications of your position on due process. I understand the desire to connect the 2, and then you connect the 2 in the context of a long narrative structure that takes an enormous amount of time, but to get through, hence the very, very long paper. But I'm wondering if you don't really have 2 papers here. So I just suggest to you that you consider splitting this paper in 2.
Guy Burnett.
Yeah, I had a question. First thing I wanted to mention is that I thought the paper was incredibly useful, and I had never read any of that before, bits and pieces, but it was very entertaining, very enlightening, and I'd love to see you just keep going and sort through this even more. It's been a lot of fun. My question, I guess, perhaps would be more methodologically, I'm not sure. You stated, both in the paper and then what you're talking about, is you want to explore the public meaning approach here and sort of see what the public was thinking on this. Is that what this meant when it was drafted, this kind of thing? And my question was, in this case, is it a house divided? We have a North and a South, right? And a South that completely disagrees with the North on a lot of these things, right? I mean, there's obviously that, and that I'm thinking of the universality there you're talking about of Bingham, where it's all persons, not citizens, this kind of thing. The South clearly disagrees with this, right? Absolutely so. And so I'm wondering, with both the due process as well as congressional power, when the public is split, how useful is that public meaning approach going to be? And that was just my sort of question. And how did you seem to go over that? It seemed that intent here would be a lot more, I guess, lend itself to that. And so I just wanted to see how you were going to tackle that, or if that was much of a problem. I'm sure you've read the literature far more than I.
Well, no, I'm still reading it. And again, it's part of what I think needs to be developed more about people's understanding. My suspicion is that there might not be as much disagreement North and South regarding persons, right? And I think this is true even among the conservatives in the House, and probably not in the South. The system of slavery was based on a concept that didn't necessarily deny the personhood of the slaves, but did deny them any kind of capacity to exercise their freedom. So, I mean, I don't know. I want to find specific examples, but just judging from the back and forth in the discussions of the debates of the 13th Amendment, which I have studied, and of course we're still dealing with members of Congress that remained in the North, but nevertheless some of them were virulently racist, right, and supportive of slavery, and believed that blacks would only thrive under a system of slavery, right? So you get very forceful arguments, but I don't recall any denial of blacks being persons, right? And that is what gave force to the abolitionist argument that even if they're not citizens under Dred Scott, they're at least persons. And that forced a response saying, well, maybe they are, but that still doesn't fall within the original understanding of the Due Process Clause, even though it uses personhood. But these are just things I'm thinking about. Your point is still the same. There might be such disagreement on these concepts that I won't be able to arrive at any kind of plausible consensus understanding of the Due Process Clause. And I worry about that. I worry about what I'm going to find when I explore people's understanding of the Equal Protection Clause versus the Due Process Clause. There might be such multiple understandings and contradictory understandings, it'll be very difficult to make the originalist point. That's just part of the burden, right? You know, I feel comfortable to at least get these ideas on the table. I think I can feel comfortable about what was going on in Congress, but my goal, and the goal in all of my work, is how does this play out in public? One last thing, I take comfort once again in finding examples within the debates of Congress where political opponents who disagreed about everything else agreed that this was an effort to enforce the due process rights of all persons. To me, it's that dyad. It's where you find, what do they say when to identify a tornado, right? You find those two places where winds are going in opposite directions. You try to find the little dyad in the radar because it's very important. I think for originalists that's true for us as well, because you can't just rely on political opponents who took that position or political proponents took that position. It's where opposing members agreed on certain matters that I think is very important, and that's what I'll be looking for. So it's a good point. Larry, thank you. Yeah, this is too long. I felt the historical story is it's complicated, right? And I'm trying to give a narrative that brings some sense to this chaos of legislative and constitutional amendment processes that were happening in the 39th Congress. And I try to put it in a context so that we understand the abolitionist language that they're using in Congress. But at the end of the day, if I just exhaust the reader, then I'm not getting anywhere. I'm not putting across a particular point. And I think you're right. By breaking this up into two papers, I will be able to address more deeply particular theoretical questions, in particular that dialogue and what they thought was happening when they passed the 14th Amendment and its implications for the constitutionality of the Civil Rights Act. I think you were right to key in on that particular talk. It needs more development as well. So I'm going to concede that there's going to be some type of major modification there. So I think you're right. I think it needs to be broken up. Chris, we're going to keep talking about this forever. Let me just make one point. Fortunately not. Right. The Civil Rights Act only protected citizens, so of course when people talk about the Civil Rights Act, they're going to be talking about the rights of citizens. That's of course, right? That has led scholars to believe that therefore the rights that were protected in the Civil Rights Act must be uniquely associated with citizenship, as rights that only attach upon acquiring citizenship. And my argument is that that's not correct, that these were the rights of citizens. It makes perfect sense to find multiple examples of people talking about the Civil Rights Act as protecting the fundamental rights of citizens. They were the fundamental rights of citizens because citizens are also persons, right? Citizens, like everyone, should enjoy, this was their understanding, citizens, like everyone, had a natural right not to be deprived of life, liberty, and property without due process of law, but it was just particularly important to recognize that natural right had been made a right of citizens themselves, therefore calling upon the duty of the government to enforce the rights of American citizens, because that's just part of the deal. So all of those examples that you found that have the Civil Rights Act described as protecting the rights of citizens fits completely within my narrative. I'm only arguing that it wasn't citizenship that created those rights. It's just that citizens held those rights as well as all persons. So that's part response.
Okay, next troika is Randy Barnett, Shakira Sanders, and Michael Rappaport.
Thanks. I'm going to make a textualist conceptual argument. It's sort of in the same genre, in the same spirit as Judd, and I have to think hard about what Judd's. I hadn't heard this before. I want to think hard about what Judd said. It's not really an originalist or historical argument yet. And I also want to suggest that I may have actually gotten some of this from John Harrison, but from so many years ago that I don't remember that I got it from John. So apologies to you, John, if I'm stealing from you. But one way to understand the structure of the Section 1 after the Citizenship Clause is that the subject of the Privileges or Immunities Clause is the making of laws. It's primarily directed at state legislators. Legislatures as to what they may do. It's the making and enforcing of already made laws, but it's about laws. The Due Process Clause is about the application of laws to individual persons, and the Equal Protection Clause, which is directed primarily at state judiciaries, but not necessarily only. And then the Equal Protection Clause is about protection, which is an enforcement function that's performed by the executive branches of the states. And so there is kind of a trilogy related to the three branches of state governments with overlaps, to be sure. And the Due Process Clause, in my view, and this is where I know I'm not getting this, I'm sure I'm not getting this from John, I think due process of law, like the law of the land provisions, did include a prohibition on irrational or arbitrary laws, and the process of applying laws to individuals would allow you your day in court to establish that a law that's being imposed upon you is irrational or arbitrary, varying depending on who bears the burden of proof and what you have to do to show that, but it goes all the way back. It's what Calder versus Bull is about. So this is law of the land, due process. That includes that dimension in the judicial branch. Now, I say all of this to try to clarify life, liberty, or property in the Due Process Clause. I think we read this, we may very well, I'm saying maybe, because I'm not making a strong historical claim, we may be reading this somewhat anachronistically through the lens of how the court started talking about life, liberty, and property in the late 19th, early 20th century as affirmatively protecting the natural rights of life, liberty, and property, when in fact, when it might be that the life, liberty, and property provisions of the Due Process Clause refer to the three things that can happen to you when laws are being applied to you. And the first thing that can happen to you is you'd be deprived of your life. That's capital punishment. The second thing that could happen to you is you could be deprived of your liberty. That's putting you in jail. And the third thing that could happen to you is you could be deprived of your property. That is a fine or a civil judgment against your property. And so these are the three consequences of the application of laws to you. And none of these consequences should happen to anybody, to any person, without the due process of law. Now, I agree with Larry. This presupposes that we actually have rights of life, liberty, or property that pre-exist. But I think that I would plug the substantive provisions of life, liberty, property back up in privileges or immunities of citizens. But so this would sort of suggest that, and I'm not exactly sure how it goes back to your paper, Kurt. But I want to throw this out as another. There's been an underlying assumption for many, many years, ever since the Due Process Clause became revived after Slaughterhouse, that somehow this is an affirmative protection. And because the courts really did talk like this, they said a law that restricts your liberty is a violation of due process. A law that takes property from you is a violation of due process. That is how they talked, and that may have been just wrong. That is, that's not what life, liberty, or property meant in the Due Process Clause. It meant these are the three things that can happen to you when laws are applied to you, and none of those three things should happen to you without the due process of law. And then we can debate what the due process of law is. For the anti-slavery people, it was largely jury trials is what they talked about more often than not. But irrational and arbitrary laws has a very long history. It would be why, for example, Bradwell would be wrongly why Chase, the sole dissenter in Bradwell, would have thought Bradwell was being wrongly decided that day, because it was a privilege or immunity of citizens to pursue a lawful occupation, and this was an irrational, arbitrary restriction on that, and therefore it would be unconstitutional. And he's the sole dissenter, and he didn't write an opinion, so we don't know, but he did think that. So it's just a different historical text, a different textual, conceptual way of breaking this down to put life, liberty, and property, I think, in a completely different light.
I too find this to be a really interesting paper, and I think as I was reading it, I was thinking a lot of how this can come into the classroom, at least my classrooms, where we begin to discuss one view of due process as merely procedural rights and another view of due process as merely substantive rights. And I was wondering, I don't feel like I see any of that reflected in the paper, and I wondered if that was a deliberate choice. And if so, I would be interested in knowing why, because from simply reading the court's jurisprudence, it does not seem like the idea of substantive due process comes about until you get around the 1900s. But you're clearly showing here that that's not true, that this due process as having a substantive component existed way before we get to the Lochner area of cases, which is why I find this paper so interesting.
Mike?
I felt like I learned a lot from this paper. I had originally wanted to ask you about the methodology point about it. This paper reads really, I know you say you're interested in the original public meaning. It really reads a lot, original intent verse.
Yes.
And I was going to ask you about that, but you talked a little bit about that, and you said you're looking into the original public meanings. I don't want to ask you an unhelpful question there. I was also going to ask you about the meaning of due process, and whether or not on the this was going to be a protection of actual substantive rights, and the equality was going to come about as a result of everyone getting the same rights, or whether there's just a narrower component of equality. But again, I don't want to ask an unhelpful question because you said you're continuing to look at that. So maybe I could be most helpful by sort of putting these 2 points together in a way. I was thinking about what I learned from the paper, and I realized, it's very interesting about what's going on in Congress, but before even, if we just look at the pre-existing law, we knew at the state level that some of the states were enforcing a due process view which was broader than a narrow procedural due process view, and some of them were not. And so it seems to me that in trying to figure out both the meaning of the due process and its original public meaning, that state evidence is going to be very important. In fact, in a lot of ways, I think on an original public meaning view, more important than what's going on in the Congress, unless you assume that just what goes on in the Congress suddenly becomes public and determinative, which I don't think you can do under an original public meaning approach.
Thank you. Interesting. I see relationships between all three of those questions going to the meaning of due process, right? And as Shakira, your point about this, it appears that we have some type of concept of substantive due process that's occurring very, very early. But what kind of substantive due process do we have? And here once again, I'd refer to Michael's paper, was just wonderful in this regard, that you can find equal protection as a quasi-substantive component, but very different than what developed under Lochner in later years. But that needs to be explored. If Mike Rappaport's right, that maybe we had a concept, a very robust, or at least an emerging concept of substantive due process that was happening in the states. Michael, I haven't found that. I distinguish the cases that maybe you're referring to in a little bit of a different way, but nevertheless, that has to be part of my analysis in terms of what was going on, because they didn't just, and this goes back to an earlier point that Brian, I think, had made. They passed a law that had to do with equality, and they used a due process argument to support a law providing a degree of equality. That's very unusual, and I think it means we need to spend more time figuring out what they thought, right? What was their concept, and to what degree did it have this equality substance to it? But at the end of the day, I'm going to agree with John here. I think this is your position. At the end of the day, I do not think we're going to arrive at a conclusion that they drafted texts that communicated federal control over the substance of tort and property, contract and real estate laws in the states that that type of substantial control over those areas were broadly viewed by the moderates and the conservatives in the 39th Congress as properly remaining under the control of several states. The radical Republicans had a much broader view. They wouldn't mind federal control of substance at all, but they were a minority position, and so it'd be unlikely that they would have gone forward with a text that would give that type of substantial control over those topics in the states. So what then was going on, and what is this concept of due process that they were moving forward with? Yes, again, that would be part of the theoretical aspect of the project, all of which is simply trying to understand what we know. And what we know is that they thought they were moving forward with due process. So that makes it a very intriguing area that I think has been underanalyzed. And this is just my first step to get into that debate. But Michael, your point about an original intent paper, okay, maybe I've conceded too much. I don't want to push too much down the road saying, yeah, I wonder what the public thought. I don't have any idea what the public thought. No, I think I may have already identified what the public thought, and I make no bones about that, and I try to talk about it in my paper. This was not the founding period where you had secret debates, okay, secret discussions that maybe were later changed in Madison's notes or something along those lines. And this was not a period where you had very limited dispersion and distribution of newspapers. There was robust publication of newspapers at this time, and deep penetration of national newspapers into local newspapers throughout the North and the South. They carefully transcribed and reported the congressional debates, all of these debates. Any member of the public that wanted to follow the debates about the Civil Rights Act and how its proponents were describing it and how its opponents were worried about it, all had access to the actual debates themselves. Bingham's speech was separately published and distributed as a paper, and it caused major political problems for other moderate Republicans at the time. So I don't want to be coy here. I'm not making an argument about congressional intent, and I think talking about what was going on in Congress doesn't box me in to making an argument about congressional intent. I think it's highly likely that the public knew exactly what was going on, or at least had widespread availability to get to those particular documents, and that includes both the freedmen who were gathering in the South, who were very worried about the limited construction of the 14th Amendment. Their goal, of course, was trying to get political freedom and the vote. So there was a lot at stake. It was being followed. It could be followed. The public did not have to wait to find out what was going on. So in the next part of my investigations, I will not be starting from zero. I think we already have a lot of information about what the public would have known.
John, do you want to?
Yeah, briefly, in response to Randy, the central exemplar of a deprivation of life, liberty, or property, which had to be with due process, was precisely an adverse judicial decree. And the move from a due process clause that limits what the courts do to one that limits what the legislatures do requires, see Chapman and McConnell, requires a piece of apparatus that treats a law as such, not the later application of the law, but the law as such, like say a black code, as a deprivation of life, liberty, or property. That is a crucial move in the reading of the due process clauses that Kurt is talking about, and whether that works and exactly how depends on some very fine details about the move from judicial decrees to laws.
Should we adjourn, or can we take two more?
Are we over?
Yes.
Kurt, this is great.